Alan Terrell, the state Supreme Court upholds the Protect Illinois Communities Act banning assault weapons.
It basically said that I, as governor, no longer have the ability to enforce a law that was on the books for 100 years.
A domestic violence abuser increases the risk of homicide by 500%.
This bill was written with constitutionality in mind. It was based on bills in other states where the same ban has been upheld.
A federal law prohibiting possession of a firearm for anyone who is under a domestic violence court order.
U.S. versus Rahimi. All right, folks, hold on to your seats, because we've got an exciting legal showdown coming up on Tuesday, November 7th. That's right. The Supreme Court is about to dive headfirst into the Second Amendment with the case of U.S. versus Rahimi. It's a battle royale that's been a long time coming, and it's all about answering a pivotal question: who are the people protected by the Second Amendment? The Supreme Court, the highest legal authority in the land, is gearing up to hear arguments in a case that could potentially redefine gun rights in the United States. That's a big deal, and if you're a fan of the Second Amendment or just love a good courtroom drama, you'll want to pay attention. So what's all the fuss about? Well, at the heart of this case is the very essence of the Second Amendment. You know, the one that says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Yeah, that's the one. Now, you might think it's crystal clear who the people in that amendment are, but as it turns out, is not as straightforward as you'd imagine. Enter Mr. Rahimi and his run-in with the law. This case revolves around a dude named Mr. Rahimi who, to put it mildly, has a rather sketchy track record. He was involved in multiple shootings, car accidents, and generally seemed to be up to no good. But here's the twist: he had firearms in his possession, even though he had a domestic violence restraining order against him. That's where the legal fireworks begin. You see, the Fifth Circuit Court decided that the federal ban on gun possession for folks with restraining orders was a violation of their Second Amendment rights. It's a real eyebrow raiser because it challenges previous interpretations of the law. And that's where the Supreme Court comes in. They've agreed to take on this case, and it's a big deal because it could potentially change the rules for everyone. It's not just about Mr. Rahimi, it's about the face of gun rights in America.
Alan Terrell, the state Supreme Court upholds the Protect Illinois Communities Act banning assault weapons.
The U.S. Supreme Court is taking up yet another Second Amendment case during the new session that began last week.
A federal law prohibiting possession of a firearm for anyone who is under a domestic violence court order.
After a shooter used a high-profile rifle shooting into a crowd gathered in Highland Park for a 4th of July parade.
The court's ruling centered on the appeal of an Arlington man who entered a guilty plea to violating that law.
The court's going to have to get to the issue of whether the Constitution forbids that, or does it permit it under certain circumstances.
So when the oral arguments kick off on November 7th, all eyes will be on the Supreme Court as they try to answer the age-old question: who are the people protected by the Second Amendment? It's a debate that could have far-reaching consequences for gun control laws and the rights of gun owners across the nation. Fifth Circuit's unconstitutional finding. We've got a case that made shockwaves by finding the federal ban on gun possession for people with domestic violence restraining orders unconstitutional under the Second Amendment. It's a real head-scratcher, so let's break it down. The Fifth Circuit, which is one of the United States federal appellate courts, dropped a shocker by declaring that the Second Amendment trumps the federal ban on folks with domestic violence restraining orders having guns. To give you the lowdown on this, let's start with the case's backstory. Meet Mr. Rahimi, a guy who was, to put it mildly, no angel. He had a laundry list of not-so-great actions under his belt, including being involved in multiple shootings and car accidents. But here's the kicker: he was packing heat, despite the fact that he had a domestic violence restraining order against him. That's a big no-no in the eyes of the law. Now, what makes this case so intriguing is that the Fifth Circuit Court, in all its wisdom, said, hold on a minute, this gun ban isn't going to fly under the Second Amendment. In their view, the right to bear arms was more important than restricting Mr. Rahimi from having firearms, even with a restraining order hanging over his head.
It basically said that I, as governor, no longer have the ability to enforce a law that was on the books for 100 years.
The U.S. Supreme Court will hear a case next term that will once again test constitutional rights to own firearms.
In New York, you've been incredibly innovative in trying to figure out how to still protect the rights of women, even given that.
The gentleman from California is recognized.
Mr. Speaker, I yield 2 minutes to Jerry Nadler.
And Mr. Bosco, I think before this committee said that people were using stabilizing braces in ways that he hadn't anticipated.
No rifle is allowed to accommodate more than 10 rounds, with a 15-round limit for handguns.
It's like a legal showdown of epic proportions, with the Fifth Circuit acting as the bold underdog taking on the federal government's gun control measures. And the result? Well, it sent shockwaves through the legal world and had folks on all sides of the gun control debate scratching their heads. So here's the big takeaway. The Fifth Circuit, in a bold and somewhat controversial move, declared that the federal government couldn't just ban gun possession for folks with domestic violence restraining orders without butting heads with the Second Amendment. This decision had huge implications because it challenged previous interpretations of the law, and it opened the door to a much bigger debate on where the line between gun rights and public safety should be drawn. It's a debate that's still raging today and is bound to impact how we view the Second Amendment in the future. Implications of the Supreme Court's 6-3 decision. First things first, the ruling from the Supreme Court in Braun laid down the law, quite literally. It declared that gun control laws can't just pop up out of thin air. No, sir. Instead, they have to have a historical basis that reaches all the way back to 1791. For those who aren't history buffs, that's the year the Second Amendment was born, and it's like the holy grail for gun enthusiasts. So the court essentially said, if you want to restrict gun rights, you better show it's been around since the dawn of the Constitution. What's even more mind-boggling is that this decision turned the tables on previous Fifth Circuit rulings. Yep, it shook things up big time. Before, the Fifth Circuit was more lenient when it came to evaluating gun control laws, but now, thanks to Braun, there's a new sheriff in town. You see, the Supreme Court made it crystal clear that a historical basis is the way to go when assessing gun control measures. And this isn't just a minor tweak, it's a whole new approach.
Alter the landscape by demanding a more individual determination, not simply per se prohibition based on that conviction.
I want to make sure they're not prosecuting the doctors of New York who are providing these services. So we had to do a lot there.
And what I'm saying is,
just answer this question. As you interpret the statute, I assume you're familiar with the statute.
The Supreme Court told us last year to only look at the historical tradition that surrounded the Second Amendment.
This bill was written with constitutionality in mind. It was based on bills in other states where the same ban has been upheld.
We could see increased risk, additional need for assistance like emergency shelter.
The old way of thinking that focused on interests and balancing acts has been shown the door. Now, it's all about the historical connection between a law and the good old days of 1791. What does this all mean? Well, it means that gun control laws are about to get a whole lot more scrutiny. Any new restrictions better have a ticket to the history books, or they might not stand a chance. Braun changed the game, and it's a win for those who cherish their Second Amendment rights. Second Amendment issues. First and foremost, the Rahimi case is expected to be a trailblazer, a precedent setter. It's like the first domino in a long line of legal battles over the Second Amendment. When the Supreme Court rules on Rahimi, it's not just about this one case, it's about creating a blueprint for how the Second Amendment will be interpreted in similar cases down the road. The decision in Rahimi is likely to become the gold standard for evaluating gun control laws. It's like a roadmap for judges, lawyers, and lawmakers. If they want to introduce a new gun control measure or challenge an existing one, they'll be looking at Rahimi as a guidebook. But it doesn't stop there. The Rahimi case is set to bring some much-needed clarity to the Second Amendment landscape. How, you ask? Well, it's all thanks to the Bruin analysis. Remember that landmark 6-3 decision in New York State Rifle and Pistol Association versus Bruin that emphasized the historical basis for gun control laws? Yeah, Rahimi is going to put that analysis under the microscope. When the Supreme Court rules on Rahimi, it'll provide more details on how the Bruin analysis should be applied in practice. This isn't just some vague legal theory. It's about giving judges and lawyers a set of guidelines on what to consider when weighing the constitutionality of gun control laws. It's like they're drawing the lines on the playing field. So if you're a Second Amendment aficionado, or just someone who cares about the legal landscape in the U.S., you'll want to keep your eyes peeled for the Rahimi case. It's not just a one-and-done affair, it's a pivotal moment in the ongoing saga of gun rights and gun control. When the Supreme Court delivers its verdict on Rahimi, it's going to send ripples through the legal world, and we'll be talking about its impact for years to come. Stay tuned. Central question. At its core, this case is like a legal tug-of-war. On one side, you've got the government, waving the banner of public safety and saying, hey, folks with domestic violence restraining orders shouldn't be packing heat. On the other side, you've got the defenders of the Second Amendment, who are saying, hold up, the Constitution says, the right of the people to keep and bear arms shall not be infringed, and we mean it.
A domestic violence abuser increases the risk of homicide by 500%.
You've written a piece called The Supreme Court Case That Has Me Worried for Survivors.
The case eventually made its way to the Illinois Supreme Court. Those supporting the law are celebrating.
And on the guns, last year we raised the age to buy an AR-15.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
So the big question here is whether this law, 18 U.S.C. Section 922 G8, is a violation of the Second Amendment on its face. That means, does it unconstitutionally trample on the gun rights of everyone, not just Mr. Rahimi? You see, this isn't just about one guy and his legal troubles. It's about setting a precedent that could affect every American. It's about establishing whether this law goes too far in restricting firearm possession for those with domestic violence restraining orders. It's a question of balance. How do we protect individuals from potential harm while respecting their constitutional rights? The arguments in this case aren't just any old arguments. They're loaded with weighty considerations. Lawyers are challenging not just the text of the law, but also its historical basis. They're asking whether the Founding Fathers, back in the days of powdered wigs and quill pens, would have ever approved of such a restriction. It's like stepping back in time to understand the intentions of the framers of the Constitution. That's all for this video, folks. See you next time.